Our next session topics is principle-based regulation of companies in ASEAN and its implication. This topic will be presented by Mr. Jeremy Hewitt, Legal Director of Reynolds Porter Chamberlain, Singapore. Mr. Jeremy specializes in advising financial lines, insurers on complex coverage dispute and their response to D&O, E&O, professional liability, and fidelity claims. He is also regularly instructed to monitor and control defense strategy of such claims in numerous jurisdictions worldwide and to draft innovative insurance policy wording both at primary and excess level. Ladies and gentlemen, please give a warm welcome to Mr. Jeremy Hewitt.
Thank you very much. Pleasure to be here. Well, corporate governance across the Asian jurisdiction is a real hot but not much has been said about what new liability exposures these new regulations could expose those businesses to. And even less has been said about how those new regulations could in turn impact Asian businesses, financial lines, errors and omissions, and directors and officers insurance. And that's why I'm presenting this paper today. So I'm just very quickly going to summarise developments in corporate governance in 3 Asian jurisdictions, take a look at their implications both for the businesses themselves and then for their E&O and D&O insurers. But before I need to do that, I need to make a few remarks just to set the scene. Well, in many ways, business is absolutely booming in the Asian jurisdiction. Insurance companies and insurance brokers are all growing their books, and sort of much more broadly than that. Inward investment into the region is increasing across the board. Returns on Asian stocks are amongst the highest in the world, and more companies are listing on regional stock exchanges. Take a look at the table up on the slide there. 3 of the biggest exchanges in the region. It just lists the number of companies listed on those 3 exchanges and their total market capitalizations as at the end of last year. It's pretty impressive stuff, pretty impressive figures. Now, undermining all of those figures is a significant improvement pretty much across the board in all Asian jurisdictions in levels of corporate governance. Governments in the region have wised up to the fact that there is a clear link between the predictable investment flows from outside the region and also to the long-term stability of capital markets within the region. So from the government's perspective, it's an absolute no-brainer. Get the new regulations in and stimulate inward investment that way. Now at this stage, I need to stand back and make a fairly obvious point. No amount of corporate governance, regulation and rules is going to eradicate bad or dishonest business practices entirely. And rules-based governance, by which I mean prescribing long lists of black and white, inflexible rules which companies must abide by, isn't always as effective as one perhaps might think. Now, to illustrate this point, and without looking at the copies of the slides in your manuals, can anyone tell me which country in the world has passed more corporate governance legislation than any other? No, it's home to lots of ambulance chasing lawyers, if that gives a clue. No. Well, America. So this is the most heavily regulated country in the world by a street, but also the most scandal-hit country in the world. They gave us WorldCom. $180 billion went missing, 30,000 jobs lost. They gave us Enron. Only $74 billion went missing this time. The CEO went to jail for 24 years, and it brought down one of the then 5 biggest accountancy firms in the world. And let's not forget this man. tricked investors out of $64 billion, and as a result got sentenced to 150 years in prison. So when one looks at what's happened in America, the world's most heavily regulated, black and white, rules-based jurisdiction in the world, one thinks, well, maybe there is a better way of doing things. And there is. There's a more flexible approach which can be taken, which in many ways can actually control and encourage good corporate behaviour better than black and white rules. And that's where the principles-based approach to regulation comes in. And we've got, in this region, we've got 3 governments that have really led the way with bringing in principles-based approach to regulation. Well, Singapore, Malaysia, and Thailand. And these countries, in contrast to other countries in the jurisdiction in the region, they have some sort of common themes: strong governments, clear, consistent policies, established infrastructure for training, learning and development, and they've got robust internal audit regulators. So principles are a great opportunity to take a new look at regulation where the US approach hasn't necessarily worked as effectively as it could. So new principles have been brought in Singapore, Malaysia and Thailand, and they've been drafted intentionally very widely. And there's a reason for this. If you draft them widely, you give the regulators latitude and flexibility to interpret those and to enforce them, and to shape governance of businesses in those countries for the better. The flip side of that, and the downside for insurers and for the businesses themselves, is that that makes the flexibility makes them inherently hard to predict how they will be policed, and therefore hard to determine what the potential liability exposures are. Just to emphasise that point, I'm just going to trot through some developments that have taken place recently in Singapore, Malaysia and Thailand. Now in Singapore, we had a new corporate governance code came in 2001. It was then revised in 2005. An incident involving Parkway Holdings in 2010 then prompted a second review of the code. Now, Parkway Holdings is one of the biggest healthcare providers in Southeast Asia. It owns this hospital, Gleneagles in Singapore. It owns 15 other high-end private hospitals across Southeast Asia. Well, what happened in 2010 within Parkway then? Well, it was this. Parkway had a board comprising of 13 directors. 4 of them were appointed by one particular shareholder, Fortis, which itself was an Indian healthcare provider, 25% shareholder in Parkway. The problem was that Fortis had also entered into separate arrangements with 3 other members of the board. Those arrangements, the details never actually came out, but what was very clear was that those arrangements gave Fortis the right to direct how those 3 directors voted in return for certain economic benefits. Nobody knows what they were. So what that actually meant, that actually gave Fortis, a 25% shareholder, de facto control of the entire board with a 7-6 or 54% majority. Now, as often happens in these cases, details of that arrangement were then leaked to the other shareholders, and lo and behold, they weren't particularly happy about the situation. So they were concerned about the disparity between the 25% shareholding and the 54% control. They were also concerned by the fact that the 3 directors who had the side arrangement with Fortis, in practice, every single vote that was taken by the board, they voted in the same way as the 4 directors who everyone knew had been appointed by Fortis. Now, taking a step back, in fairness to the 3 directors, there was no suggestion that they'd acted improperly at all. And there was no suggestion that their informal arrangements conflicted with or breached the code of governance that was in force at that time in any way. But nonetheless, it gave Singapore a tricky sort of public relations problem. It didn't look good. And one could easily envisage a situation whereby the three directors' obligation they felt to Fortis, under their special arrangements with them, could have conflicted with the fiduciary duties that they owed to the company, Parkway. In that situation, there'd be a conflict of interest, and they would have to step down from the board. The Singapore central regulator, the Monetary Authority, appreciated this and appreciated that it had to act fast, and so it did. It initiated a new consultation process, and a new version of the code came in last year. There's a couple of general comments about the code itself, and then there are three specific provisions which do merit a few words. The code itself, it applies to all companies listed on the Singapore Stock Exchange, so all 800 of them. It gives 16 principles of good governance, and they are, as I've said before, they're widely drafted, so it's flexible for the regulator to enforce them, but difficult to identify how it will enforce them and what the exposures are. What we do, however, know is that companies and directors with sloppy governance are going to get caught. Insureds who breach the code are going to get into deep trouble, and regulatory enforcement actions are notoriously difficult to defend in Singapore. If you have a look at the Monetary Authority website over the last 2 years, you'll see 108 different enforcement actions have been resolved. Every single one of them resulted in censure of the insured in some way. So if you've got an insured with sloppy governance or sloppy directors, A, they're going to get caught, and B, when the enforcement action inevitably follows, they're going to lose it. In terms of what this means for E&O and D&O insurers, if you're insuring Singapore companies, you've got to brace yourselves for more enforcement actions against those companies and their directors, and an increased exposure both to defence costs and to regulatory costs. That's the bad news. The good news is that any fines or penalties that are imposed, they're not normally covered under public policy grounds, and they're normally specifically excluded from the wording itself or carved out of the definition of loss. So these developments won't affect your exposures to regulatory fines and penalties. So which of the specific principles are worth particular attention? The first one is Principle 2. I've quoted some of that principle on the slide. The boards have to have strong and independent element, able to exercise judgment on corporate affairs independently. Independent directors should make up at least 1/3 of the board. And well, what is an independent director? Well, and this is where Parkway comes in. It's a director who has no relationship with the company, other than as a director, other group companies, or, and this is really where Parkway comes in, or their significant shareholders or officers. So what we've got here, in one word, is decentralisation. The problem is that in the UK and in the Channel Island and Caribbean offshore jurisdictions, or common law jurisdictions like Singapore and Malaysia, we've had principles-based regulation for 7 years now. And experience from those jurisdictions tells us that that decentralisation like this can backfire absolutely spectacularly if it's not policed properly. The most spectacular example of that is the Weavering case. Just to give you a little bit of context, Weavering was an investment fund. It collapsed, having suffered losses of over $100 million US. It was put into liquidation, and as often happens, the liquidator then stepped into the shoes of the fund and sued the directors for not doing their job properly. But these two particular directors had done their job so badly, they were accused of willfully neglecting their duties. There was a long trial, very expensive to defend, and the court ultimately agreed with the liquidators. the directors had done an absolutely shambolically bad job. In essence, they'd been signing documents for years which they hadn't even read, let alone understood, and they got hauled over the coals for it, and frankly, quite rightly so. So they were found guilty, they were found liable, and an order was made against them to repay the investors the hefty sum of $100 million US. The problem is they were just two individuals, so they couldn't afford it. So the judgment was a complete Pyrrhic victory for the poor investors who've still lost their money and are hardly going to get any of it back. Now the facts in Weavering were extreme, but they do highlight the risk, as I said earlier, that independent directors can either spread themselves too thinly, or they can just simply do a bad job, unless Principle 2 is going to be enforced robustly. And the decentralisation that Principle 2 brings in might not help with that. In fact, it might actually make it worse. That's what happened in Weavering. One little nugget of good news for the E&O and D&O insurers is that you can actually flush out this type of information that you need in the underwriting process. If you ask for copies of the directors' CVs, ask for details of their other board appointments, and that information is all in the public domain, certainly in Singapore and here as well. So the risk can be flushed out during the underwriting process. Now at this stage, you might think, well, hold on, what on earth is a case that took place in the Cayman Islands, literally as far away over the other side of the world as you can possibly get? What on earth is that case got to do with how businesses and funds are running their businesses here in Southeast Asia? Well, it is relevant, and it is relevant for two reasons. First of all, the Cayman Islands, where Weavering was litigated out, is a common law jurisdiction. It's based on English law, and the case will therefore be persuasive and perfectly citable in proceedings in Singapore, in Malaysia, in other common law jurisdictions in the region, so in India and Pakistan. It'll also be persuasive and citable in other jurisdictions, Mauritius and Sri Lanka, where they're not completely common law based, they're a mix of common and Roman law, but common law cases are nevertheless relevant there as well. So legally, that's why it could be relevant to the fund and the business industry here. On a practical note, we've got over 1,000 private equity, venture capital and hedge funds and asset managers incorporated in Labuan and Mauritius. Most of those businesses are insured or reinsured into the KL or Singapore markets. So are many of the numerous onshore investment funds and managers, both in Singapore and in Malaysia. So, a further issue coming out of the requirement for independent directors is conflicts of interest. Now, requiring independent directors to be an element of the board should well be an effective check and balance in most cases. The problem is, and that's why we're all here in this room, things can go wrong sometimes. And when they do, this sort of decentralisation of control and setting up two separate bodies of directors on the board, the independent directors and the non-independent directors, is just a conflict of interest situation waiting to happen. So when things do go wrong, and this has happened numerous times already in the UK and the Channel Islands and the Caribbean, when things do go wrong, the independent directors will blame the non-independent directors and vice versa. And all of a sudden, you've got two sets of defence costs, two sets